So, my court case was Vernonia School District versus Acton. The question that was raised was, does random drug testing of high school and middle school athletes violate the reasonable search and seizure clause of the Fourth Amendment? So, Vernonia School District is located in Vernonia, Oregon, and is made up of one high school and 3 grade schools. And in the mid-1980s, school officials noticed a sharp increase in drug usage among students, and students were noted talking about their attention to the drug culture. In 1988 and 89, the school district had twice the number of disciplinary referrals compared to the early 1980s, and student athletes were considered leaders among the drug culture within the school district. The football and wrestling coaches admitted to witnessing major drug-related injuries, and the school feared more injuries, so in response, the school district offered special classes, speakers, presentations, and drug dogs on campus to help prevent a further increase of drug usage. And that didn't work, so the Vernonia School District adopted a mandatory drug testing policy for all student athletes at their schools that went into full swing in 1989. So the drug testing protocol was all student athletes were required to submit a drug test prior to the start of their season. And during season, each week 10% of student athletes were chosen at random for urine samples. And if a student tested positive, they had a choice to attend counseling and submit 6 weeks, or they had to sit out their season. So James Acton was a 7th grader at Washington Grade School in the fall of 1991. And he wanted to play football, but he was denied participation when he didn't want to sign consent for drug testing. So the family school sued the school district for violation of the Fourth Amendment. A federal district court upheld the policy, but appellate court reversed the decision on the basis that the policy did violate the Fourth Amendment. So then the case was argued in the Supreme Court on March 28th, 1995, and was decided on June 6th, 1995, in a 6-3 decision in favor of the school district, claiming that the drug testing of student athletes did not violate the Fourth Amendment. So the Fourth Amendment only protects against unreasonable search and seizure, and although a search is considered reasonable with a warrant, the Fourth Amendment does not require showing of a probable cause in every single case. So when special needs outside of ordinary law enforcement make obtaining a warrant impractical, the Fourth Amendment allows officials to dispense with the formality of obtaining a warrant. So such special needs include student athletes, which adhere from public schools because school officials have to maintain order within their campus. So even though school officials are agents of the state, they have the authority to act in loco parentis and safeguarding children under their care. So the court established that student athletes have a lesser expectation of privacy compared to their peers who are not athletes. The court noted that locker rooms offer little privacy, and athletes already subject themselves to additional regulation and medical screenings. So a related case is New Jersey v. TLO, which questioned the Fourth Amendment on unreasonable search and seizure. So to address the constitutionality of a search of a public high school student. So a public high school student was caught smoking in a bathroom and further searched by school officials. Drug paraphernalia, marijuana, was discovered in her purse. She claimed it violated her Fourth Amendment rights, but in a 6-3 ruling, the court stated that the search was reasonable. Another related case was Board of Education v. Earls, and the court upheld the constitutionality of mandatory drug testing by public schools of students participating in extracurricular activities. So the legal challenge to the practice was brought by 2 students, Lindsay Earls and Daniel James, and their families against the Board of Temesca, Oklahoma, alleging that the policy requiring students to consent random urinalysis testing for drug usage was a violation of the Fourth Amendment, but they said it was protected. And then in a 6-3 favor of the Vernonia School District, the Supreme Court ruled that drug testing of student athletes was indeed protected by the Fourth Amendment.